Hi to everyone. I'm Zaira Zafarana, and I'm the coordinator of the UN program for the International Fellowship of Reconciliation. And we partnered together with WRI and the QUNO, specifically about conscientious objection. IFOR is a spiritual-based peace movement, and it started right in 1914 with the formal refuse to take part in the World War I. And the first members were objectors, so this is part of our roots. And I'm pleased now to introduce to you the first speaker, Rachel Brett. She is based in Geneva, Switzerland, and is the UN representative at the UN of the War Resisters International. And it's also part of the WRI's Rise to Refuse to Kill Committee. She retired from Quaker UN office as their Human Rights and Refugees representative after over 20 years, during which she helped to gain recognition of conscientious objection to military service as a human right. She serves on the War Resistor International Right to Refuse to Kill Committee and gives an overview of conscientious objection in international law. We thank her for being here, and I give the floor to Rachel. Thank you, Rachel.
Thank you, Zaira. Let me see if I can actually work the technology. Can you actually see my screen presentation? Would someone? Yes, thank you. Excellent. So I was asked to give an introduction to strategic litigation, and that's what I plan to do, first of all, with the sort of framework, and then giving one specific example. So first question, what is strategic? Why is it not moving on? That's an interesting question. Yes, what is strategic litigation? The simple thing is that it's really just the use of the court or any kind of a judicial process to create or be part of a strategy to create systemic change. So it's not just about an individual case and trying to address that individual case or situation, but it is about that systemic change process. It can be local, national, regional, or international. But as I say, the quality that is so important is that it is this fact that it is intended to make a big change, not just resolve a particular case. So it is part of a strategy. It's not something that is a one-off activity all on its own. I mean, obviously you can do it like that, but then it loses most of its point as strategic litigation. But it's also important to recognize that sometimes this is not a useful route. It may not be available at all. For example, the state may not be a party to the relevant convention or complaints procedure, or you may not be able to seize the court with the case for whatever reasons, or in fact, it may not be useful or appropriate. And when considering strategic litigation, the factors to consider are, first of all, obviously, is this a legal issue or can it be framed as one? Secondly, is there a court or a body where it can be raised? Are the courts independent and well regarded? This can be a very important consideration because would a court decision address the problem, have a widespread effect, or add significantly to the overall strategy? If the answer to that is no, then you're probably not thinking that strategic litigation, or you shouldn't be thinking that strategic litigation is the way to go. And then finally, and very important again, what would be the consequences of failure? If the decision goes against you, how damaging could this be? Or is this something that would not be such a big problem that you couldn't have another go or change your strategy? The next thing to think about is the role of organizations, and that can be WRI, for example, it can be a national NGO, or it can be different kinds of groups. And depending on the nature of the organization and of the judicial process that you're planning to use, your role can be to bring the case itself, to support and or guide others in bringing the case, or as what is called a third-party intervener, an amicus curiae, a friend of the court. But when in any of those roles, it is really important to have the right case, that it is well presented, that the court and judge or the judges have all the information and the legal arguments to help and encourage them to make the right decision. But even if all that works and you get the right decision, it's still important to do follow-up, because the court decision on itself may not get you as far as you would like. Because again, in most instances, the court itself considers that it is addressing a specific case. Sometimes it can be larger depending on the court, but and so you then need to make sure that that information gets out, that it is picked up by others in whatever form, whether it's other lawyers, other courts, other activists, in the media, to ensure that you get the maximum benefit from a good judgment. So let me give you one specific example, which is indeed how we got the recognition under international law of conscientious objection to military service as a human right. And not surprisingly, there was a long process behind this, but I'm not going to go into that because you do have the next webinar, which is going to be on the UN processes. So just to be aware that I'm only giving you the focus on the strategic litigation part in order to establish that international principle. So what we needed was an individual case to the UN Human Rights Committee, which is the body that oversees the International Covenant on Civil and Political Rights. To maximize our chance of success, the case that we needed had to be really clear and really strong. In other words, it needed a country which had an active military conscription, so this was not theoretical, that there was no provision for conscientious objection, so we weren't going to get into debates about what kind of alternative service or whether the alternative service could be longer than the military service or any of those kinds of issues. And we needed a conscientious objector, or more than one, who was a pacifist, not a selective or a political objector. Again, so there was no debate that this was a based purely on religion or belief, not on political opinion or other factors, and preferably on really readily understandable grounds, and whose credibility was not in doubt. And finally, who had suffered a significant penalty for their objection. So again, the decision-making body, the Human Rights Committee, would have to consider that this was a serious issue. It wasn't trivial. And so, as I say, with that sort of group of criteria, we knew that the committee would have to address the fundamental issue of whether the covenant requires a state to accommodate conscientious objectors. In 2004, we got the perfect case from the Republic of Korea. And I don't know whether they're going to tell you anything about their side of the story, but they had gone through a long process whereby this was 2 Jehovah's Witnesses who had been imprisoned for their refusal to undertake military service, whose cases had gone through all the Korean courts, right to the Supreme and Constitutional Courts. And we worked with them and their lawyers to submit the case to the Human Rights Committee, making sure that we had all the information in the format the committee liked it, that we made clear that all the procedural requirements had been met, etc. And as I say, after we'd done a lot of work with the Human Rights Committee itself. And 2 years later, indeed, the committee adopted its groundbreaking decision that the government was required to provide for conscientious objectors as part of the right to freedom of thought, conscience, and religion. But I want to give you the next little bit as well, because this is where I said the follow-up is also important. Unfortunately, this did not immediately resolve the issue in the Republic of Korea, even for the individuals concerned, if I remember rightly. But it did play an important role, and we'll hear some more about what's happened in Korea since then. But one of the significant things that it was able to be used for was in Colombia, for example. Now, why would a decision about South Korea be applicable in Colombia? Because in the Colombian constitution, and Maricely can probably tell you more about this if she would like to, there is a provision that ratified human rights treaties have effect in their domestic law. And previously to this decision, the Constitutional Court had said that this conscientious objection wasn't protected under the Constitution. And so this enabled the Colombian NGOs, again with support from the internationals, including WRI, to go back to the Constitutional Court. And indeed, it changed its position on the basis that this was now clearly recognized under a treaty to which they were a party. It also formed the basis for the subsequent judgment of the European Court of Human Rights in the case of Bayatian versus Armenia, where WRI, QUNO, Amnesty International, and CPTI submitted an amicus curiae brief, a friend of the court, a third-party intervention, which, amongst other things, presented to the European Court the case law of the Human Rights Committee, including this groundbreaking decision. And that led the European Court to actually reverse its previous tendency to refuse to accept that this was part of the European Convention and protected under it, and it followed the decision of the Human Rights Committee in saying this was protected under the European Convention on Human Rights. And for European countries, this is important because the judgments of the European Court are binding on states in the Council of Europe. Again, that doesn't necessarily mean that all states, although Armenia in fact did implement and has recognized conscientious objection, it doesn't necessarily mean, unfortunately, that all European states have, or that they follow the judgments of the court in the way that they should. But that again is part of the follow-up process that is required. Thank you very much.
Korea case. And I'm pleased to welcome our 2 speakers. The first one is Choi and the colleague Yongsuk Lee. They are members of World Without War, based in Seoul, and they will be speaking more about their campaigning for CO in Korea. World Without War was founded in 2003 as a network of pacifists and anti-militarists in Korea and has been campaigning for peace since then. Conscientious objection has been a particular focus in their campaigns, and their work was very important in setting the right to conscientious objection be recognized in Korea in 2018, which has been a result of a long and resilient campaigning. So I'm pleased to give the floor to them, and thank you for being here with us.
Okay, thank you, Zaira. And I shared my PPT. Just move on. Okay. Greetings, everyone. I'm Yongsuk Lee from the World Without War. Thank you for the opportunity to talk about the Korean conscientious objection movement, especially strategic litigation in this webinar. While preparing for this presentation, I was able to review the strategy of the Korean CO movement once again. The World Without War has tried to achieve the right to CO in various ways. We have targeted both the legislative and executive judiciary to be recognized for CO rights. Sorry. Among them, the judiciary was the most responsive, and consequently, the role of the judiciary took precedence over the legislative and executive in the legal recognition of the right to CO in Korea. I can only speculate why the judiciary was more favorable to the CO than legislative and executive. I think the main reason is that the judiciary could be less concerned with the public opinion than the legislatures and the executive, which are prone to be shaken by public opinion against the conscientious objection. Several of the male human rights lawyers say they start the CO campaign out of regret for ever witnesses CO who were punished when they were serving as a military judicial officers. Male judges who judge conscientious objectors have also experienced punishing COs in the past as military justices. Like human rights lawyers, some of them may have felt sorry for punishing COs in the past. I'm guessing that feeling had an effect on the not guilty verdict. The strategic litigation in Korea can be divided into two main categories. First, it's a domestic procedure. The domestic process is divided into the following three parts: litigation procedure, constitutional appeal, National Human Rights Commission. The first thing World Without War prepared was the proceedings. This was possible because there was a group of human rights lawyers, Minbyun, in Korea. Until the 1990s, COs were tried in a military court, sentenced to 3 years in prison, and imprisoned in military prisons. as civil rights lawyers began giving free arguments on behalf of Elbas witness CEOs to the court. CEOs were tried in private court and the sentence was also reduced to 1 year and 6 months. The lawsuit claimed innocence. Ultimately, the goal was to receive recognition of the CEO as well as to improve the treatment of CEO in prison through lawsuit with the help of human rights lawyers. Continuing trials and going to jail was effective in publicizing the issue to Koreans. CEOs organized the supporters to go to listen to CEO's trial, and when convicted and arrested, they made comments or informed the media to publish articles. In Korea, the Constitutional Court has the legal final interpretation authority. Unless the National Assembly made a law, the Constitutional Court decision was necessary in order for the right to CEO. In total, 3 constitutional petitions were made, but in 2004 and 2011, they were not recognized. Finally, in 2018, the right to CEO was recognized. When making a constitutional petition, World Without War considered the propensity of the constitutional judges. In 2011, the composition of the constitutional judges were not good, so World Without War didn't have much expectations. The National Human Rights Commission of Korea was established in 2001 with the demand of human rights movement. So many human rights activities had high expectation for the launch of the National Human Rights Commission. The CEO movement tried to be registered as a first appeal with the National Human Rights Commission, but it became the second because there was more diligent groups. In particular, we actively used the National Human Rights Commission to rectify the discrimination and human rights violation that prisoners suffered in prison. It proposed recommendations such as freedom of religious assembly in prison, vegetarian rights for inmates, and access to books. Since the National Human Rights Commission of Korea's recommendation were not binding, they were not immediately reflected in many cases. But since the National Human Rights Commission of Korea was recognized as a state agency with credibility, news of their support helped improve the perception of society as a whole. In Korea, strategic litigation was an effective method because institutions as a court, Constitutional Court, and National Human Rights Commission of Korea have authority that is more widely recognized compared to other government ministries. Accumulating judgment or decision, acknowledging the rights of CEOs, and accumulating the number of innocent convictions in lower court ultimately played an important role in eliciting legal recognition of the right to CEO. Second, utilizing the UN system. This contents overlap with Rachel's presentation, so I will keep it short. The Korean CO movement actively utilized the UN system from the beginning. The resolution of the Committee on the Convention of Freedom, the resolution of the Human Rights Committee, and the Human Rights Council's National Human Rights Review, UPR, were all utilized. We got a lot of help from Rachel, and a Conscientious Objectors Guide to UN Human Rights System was also of great help. World Without War made CEOs aware of the implication of using UN procedure and gathering CEOs to file a complaint with the Committee on the Convention of Freedom. In addition, we prepared to submit a written opinion from the Korean civil society and submit a report that refuted the Korean government report on the recommendation of UN mechanism. The recommendation and decisions of UN mechanism vary from government to government, but they have been useful in pressing the government. The UN's recommendations and decisions have also had a great influence on actors in frontline courts. The judges cited international legal ground and recommendations from the UN as the main reason for acknowledging innocence in the judgment. Thank you very much.
Thank you very much, Yongsuk, and thank you for demonstrating, as we've broken this series down into different parts, that actually mostly people are working with multiple different ways of campaigning for CO at the same time. So the strategic litigation sits alongside the work of trying to make sure that people across the Republic of Korea are aware of COs, aware of their rights and their needs. So thank you for that, and for this really helpful explanation of how the work at the country level and in the lower level courts met with the work of strategic litigation at the international level, and how that together helped to make the changes that you've worked so hard for. We're very, very grateful to Yongsuk for being here, particularly because it's quite late at night in the Republic of Korea. So our colleagues from World Without War may not stay for the whole question and answer session. So we really invite, if you have questions specifically for them, now is a good time to ask them. And we will take a few questions now. I see there have been some questions coming in the chat box. The general questions we'll save to the end, but the ones that are specifically about Republic of Korea, we'll take now to make best use of while we still have you online with us before you need to leave because it's late. So I have a question here from Rudy, who says, we heard that there is a new complaint filed to the Constitutional Court because of the punitive alternative service. Could you say something about that? And we have another question that's also about Republic of Korea, which says that considering the fact that Republic of Korea has a long pacifist tradition, is there anything from the culture that inspires that? So one that's more general about Republic of Korea, and one question very specifically about the next stage, perhaps, in strategic litigation. So if you could start with those questions, that would be excellent. Thank you.
Thank you. And well, maybe I can translate, help translating what he's going to say. Maybe I can answer the second question about the culture. Maybe Yongsuk, if you want to say something, and you can also add some comments. I think of Buddhism, maybe That's the very long pacifist tradition. And actually, the first conscientious objector who are non-Jehovah's Witnesses and publicly declare his conscientious objection in 2001 was a Buddhist. So we got a lot of support from the Buddhist human rights groups. Yeah. 용석아, 너 혹시 덧붙이고 싶은 거 있어? 그거에
아니,
대해서?
너무 어려운 질문이야. 없어.
두 번째 거 그러면 대답할래? 뭔지 알겠지?
근데
최근에
우리가 대답해도 되지 않아? 사실 기사에 난 거 이상으로 내가 알고 있는 거 없는데.
기사에 난 거나 잘 안 읽어봤어.
여아의 증인이고 두 아이의 아버지고 너무 징벌적인 데다가 이렇게 두 아이의 아버지인 경우 현역 군인은 좀 배려를 해주는데 그런 배려가 전혀 없고 이런 것들로 징벌적이라고 소송을 낸 거고, 그리고 정확히는 말 안 하지만 여아의 증인들은 이걸 계속 다음에 한 사람들도 계속 하려고 준비 중인 것 같아.
So the one who filed a complaint to the Constitutional Court was Jehovah's Witnesses, who now actually on duty of the alternative service in the prison, and he was a father of 2 children. So but this isn't just imagination, but if he go to the military, he can get some benefit because he's a father of 2. But now he served the alternative service, so he has to stuck in the correction facility for 3 years, and so he said he think it's really unfair, so that's why he brought his case to the Constitutional Court, and that's what we got so far.
Thank you.
Thank you.
Encourage if there are any other questions specifically for our friends from Republic of Korea, please do type them in the box because that helps with the translation. But also maybe on this question, while people are thinking and maybe typing their questions, about the case that you're just saying about the punitive alternative service. So the case has been lodged. Do you have any idea of the timeline for it? Like when things might change, when it might be decided, when there might be opportunities for others on the call to provide support or solidarity. So any other things you'd like to say about that case would be helpful.
용서가 들었어? You mean this specific case, right? Yeah. 지금 그 케이스를 우리가 어떻게 도울지, 그 과정이 어떻게 될지, 언제 결정이 날지 이런 거에 대해서 예상할 수 있는 지점들이 있니?
언제 날지, 결정이 날지, 진행이 될지 이런 것들을 전혀 아직은 이제 진정을 한 거라서 잘 모르고, 그리고 내가 받은 느낌은 여아의 증인들이 이 케이스를 가지고 우리와 협업하려고 하는 것 같지는 않고, 그리고 우리는 우리 나름대로 이제 오수환 씨가 처음으로 통과를 했잖아. 그래서 여아의 증인이 아닌 변협가업자들도 대체 복무가 시작되면 그들이랑 함께 좀 캠페인을 해야 되지 않을까 생각하고 있어.
So we just heard the news. So we are not talking about this procedure. How can we support them yet? So to be honest, we don't know. And it takes really long time, I think. And this Jehovah's Witnesses, they are not very politically active, not very cooperating with us. So we need to discuss with them.
Okay, thank you. I just
no,
that's fine. No, that's perfectly fine. It's new news for you and for us. So thank you very much. Thank you very much indeed for sharing what you did, for joining us, for being here so late, and for the really powerful reminder that I think comes from your work of both what can be achieved through strategic litigation, but also the reminder that this is often not the end of the work. So thank you for sharing that with us today. And now do stay with us if you would like for the Q&A at the end, but we understand if you have to leave. So thanks from everybody on the call. And Zaira, I hand over to you.
Thank you again for the interesting presentation about the Republic of Korea. Today, during our webinar, we will address another case. It's about Colombia, and we are very pleased and grateful for the participation of the next speakers. They are both from the association called ACOOC, as Acción Colectiva de Objectores y Objectoras de Conciencia. It's a civil society organization, and there is the participation of men and women who have been building and promoting alternatives to militarism, to the militarization of society and patriarchy in Colombia for more than 10 years. The purpose is to contribute to the strengthening of the legal, political, pedagogical, and communicative capacities of communities to confront recruitments and the militarization of the youth lives. They promote nonviolence and conscientious objection and work to contribute to the construction of a culture of peace. They work on the legal area, and they work for the legal and political recognition of the right to conscientious objection in order to eliminate compulsory military service in Colombia. I'm pleased to present the two speakers. We have Maricely Parada Abril. She is a conscientious objector herself, a human rights defender, and a lawyer, and she has been trained in law, communication, alternative to violence, conflict resolution, with a gender approach and theology. She has worked in the promotion and search for guarantees for the exercise of the right to freedom of conscience, conscientious objection, and the application of due process in the administrative proceedings aimed at defining the military status of young people in Colombia. And she is currently the legal representative of the organization. And her colleague, Saul Alonso Santamaria Quiroga, is a lawyer, and he is a specialist in contentious administrative law, and also works on the political legal accompaniment team of ACOOC. His professional experience has been developed within the framework of political legal accompaniments for the defense of the rights of young people at risk of recruitment, and in the accompaniment of conscientious objectors in their process of formal recognition. He has also carried out investigative research in the development of his work in defense of the human rights of young people. So now we are pleased to hear from them, and we thank them for being here. In Colombia, it's early morning, so this webinar is quite demanding for our presenters, and we thank all of them. Thank you.
Buenos días a todos. Qué pena.
Good morning, everyone. We apologize for the technical problems we've had. So let's just start with our presentation. Today, we want to talk to you about the arbitrary detentions by the Colombian military. I would like to start by saying that in Colombia, conscientious objection to the military service was established in 2009 with a law 6729. There were major mobilizations in order to ask from the government to enable people to reject participating in war without any consequences. However, the government, which is in charge of... Sorry, could you please speak a bit slower? just to help the interpreter. Okay. So the military, which is the authority which is in charge of recruiting members, denied this request based on the fact that there is no legislation that would enable them to do that. So in the years following 2009, when the decision C728 was issued, we had to wait until the decision C879 was emitted in order to recognize a consensus objection in Colombia. It is therefore important to take into account that the Congress of the Republic emitted that decision in order to, as a response to the pressure from different human rights organizations, both national and international, which were claiming these kind of measures for consensus objectors. So how has this new law been implemented in the country since this law was approved? 840 cases of consensus objectors were presented. 602 of these cases were recognized as consensus objections, and the rest were denied. Of all those that were denied, only 7 were appealed. 9 were appealed, 7 of which were approved and accepted. This has been the result of a lot of legal work that's been carried out in order to recognize consensus objection as a right in Colombia. If the number of requests is very high, it is true that we need to say that the official data is not taking into account all the real requests that are being presented. Very few of those cases are actually being taken into account, are going through all the different processes. All these cases usually have 4 elements in common. First of all, consensus objectors have lots of different difficulties and prerequisites in order to be able to present their case. Secondly, those requests that are initially approved and that go through this initial screening are not taken to the authority which has the competency to deal with their case. Thirdly, once the process is initiated and the case is studied, sometimes the case is left unattended indefinitely. And finally, when the consensus objector receives an answer, and if the case is rejected, the authority in charge of this case usually uses different measures to try and avoid this case leading to a final sentence. You must not forget this, because the support that members of this, participants in this room have helped us, but we need to take into account all these different problems, because in cases, the emergency, for example, of the COVID emergency has been used an excuse to stop or to prevent resolution to certain cases. So this needs to be taken into account. What happens with those cases which are successful, we need to take into account that in most cases, we needed the help of a judge for the consensus objector to be recognized as such. So it is always important to take into account the importance, the role of a judge and the help of lawyers. So the process is not very, it's not really helpful and doesn't always lead to a successful result. So we need to take into account that we are faced with the following problems when taking into account what the Colombian government has done regarding consensus objection. We currently have a structure where the consensus objector has to present their objection to a technical body. The problem is that this body is mostly composed of members of the military, which is the same entity or body that is in charge of conscription. So this is a bit contradictory. It doesn't make any sense that the same body that is in charge of conscription through a quota system, which every year conscripts between 20 and 30,000 men and women, it cannot be in charge of deciding who is a conscientious objector. This doesn't make any sense because this is not objective and lacks independence. Regarding the right to conscientious objection, we need to say that this is not just a formality. It is important to take this into account as a real objection, and it's a right that people have in the Colombian society. And as long as it's not considered as such, it won't be taken seriously by the authorities. Conscientious objection is always limited. And I'd like in this now to mention the case of Sergio Sainz, who requested to be recognized as a conscientious objector, but his request was rejected because it was said that he wasn't part of a church and there was nothing that certified that could prove that his arguments were true and faithful. So basically, we are faced with different challenges in order to be able to actually be reconsidered as a consistent objector. ACOOC wants to provide you with these recommendations. First of all, we need to take into account the different interdisciplinary measures that are available to conscientious objectors. Regarding strategic litigation, we have tried to raise awareness between the youth to explain that conscientious objection cases are not independent and that it is a real right and freedom that all people should have. It is important to use strategic litigation in order to try and find alternatives to try and end with the competency of the military authorities to decide on conscientious objection cases. And this is something that we can still doing. And now I would like to talk to you about arbitrary detention as well. My colleague is going to talk to you about that.
Bueno, rápidamente porque tenemos muy poco tiempo.
I am aware that we don't have a lot of time, so I'll try to be brief.
De alguna manera.
Sorry, but the speaker cannot be heard.
Está silenciado el micrófono, se estaba escuchando como un ruido extraño. ¿Pueden revisar esto, por favor? Se escuchaba como un eco. Sigue silenciado. No, aún no se escucha. ¿Pueden revisar el micrófono, por favor?
Ahora sí.
Can you hear me now? Yes.
Bueno, entonces rápidamente, en detenciones arbitrarias.
Arbitrary detentions. We have been able to move forward regarding arbitrary detentions, and we have been faced with many challenges as well. But let me talk to you about it briefly. We started doing this work in 2007, 2008. This was started by organizations Medellin, and it led to a decision which was issued in 2008. with the presentation of 3 cases of 3 conscientious objectors who were arbitrarily detained. Until up to that point, we always heard about raids and arbitrary detentions, but at the time, it used to happen with the military patrols that would go out on the streets and would stop anyone who didn't have the appropriate documentation saying that they'd already completed their military service. In Colombia, it's always been said that anyone that doesn't have their military card is at risk of being taken, and especially those who have not been presented, didn't attend to a request to join the military. So it was always believed that these people were at risk of being recruited at any time. But then there's Article 11 that establishes that all Colombians have to undergo the military service if they're aged between 18 and 50. However, this is the legislation that we had at the time. Nowadays, this is still happening, even though we have moved forward with, and things have changed since 2007. This decision of 2008 continued being amended, and with the support of WRI and other organizations, as well as with some of the agencies of the UN, we were able to obtain a different outcome, and this led to a permanent dialogue with the High Commissioner of the United Nations, which helped from then on to include that issue within all the different agencies within Colombia to be so that it could have a positive effect. We requested for arbitrary detentions to be considered and declared as unconstitutional. The result was decision 879/2011, where the Constitutional Court said that it could not be understood that a point in the Law 43 could not be considered as the military authorities having competency to carry out those raids in order to identify people that had not completed the military service. And this could not lead to arbitrary detention. So basically that article was banning that kind of practice. Further on, another aspect was added to all of this, and it's that we presented 2 different cases. It was a guardianship case, and it led to another decision which established and ratified once again that these kind of raids, these practices, which were a type of arbitrary detention, were illegal, and they were very similar to some other types of detentions, administrative detentions, which are some sort of crime, really. So it was ratified that these types of procedures are not allowed by the constitutional. So there was a request for them to be declared unconstitutional because they were affecting personal freedoms. And this led to the Constitutional Court to establish that the military authorities did not have the competency to carry out these sort of actions. We use the help of different anti-militarists to accompany different objectors and all the victims of these practices, and this helped also include or used the pressure of the civil society to be able to make sure that it was made clear that this type of practices by the military was illegal. This empowered all of us, and it also enabled us to use legal mechanisms and resources, and for those to be used by the youth, including also a dialogue with the media and different representatives, congressmen and women in Colombia. Another key point was the participation of different other district bodies who also helped with denouncing all these actions. However, even though we have succeeded in all this, and the new conscription law includes a ban that says that under no circumstances may someone be detained arbitrarily, and no one in Colombia can be detained down the street. In practice, this is very different because these raids and these detentions continue to happen in Colombia. There was a very important lobby that helped us and taught us different lessons, and that lobby continues to work. However, we need to take into account that the situation has changed greatly as a result of the COVID pandemic. So all this reality has changed, and it has shifted the focus onto different other issues. So the problem now is not that this issue of arbitrary detentions um, is changing. The problem is that the focus is being shifted elsewhere, and the practices are changing, but they are still there, and lots of the youth can still be recruited through that conscription. And the worst thing is that the perpetrators are not being judged, and there's a lot of impunity. There is also a lot of verbal and physical abuse against those that have been conscripted through those raids. And lots of people are still being invited to address the military situation by being given a card, a military card, when they're walking down the street. Then when they um, go to their appointment, they are recruited unless they are sometimes accompanied by people, members of our association, who try and help these youth. And then in some cases, these people are obliged, they're forced to sign certain documents under pressure. And I'm going to try and avoid saying lots of the things that I wanted to say since we don't have enough time. But I would like to add that, for example, there's a case where someone on the day of the 18th birthday were recruited into the military, and they were given that military card. Last year, the second half of last year, the military of Colombia made public the need that they needed to add new members to the military. They needed new conscriptions. But the problems that we've seen when we've accompanied different people, the youth, over these past 10 years, we know that the only way in which they can continue having the same number of members in the military through that conscription, through those conscription practices, through those arbitrary detentions and those raids. Because as you'll see, what we've been able to attain through those campaigns is to stop the transfer of the youth from in lorries without complying with all the different requisites of those processes. But in reality, we are facing an issue, and it is that it's very difficult to prove what is happening now. They are still being conscripted, they're still being recruited, but in a very indirect way. So now it's very difficult to identify those cases and to prove these illegal practices. And it's difficult to prove to the public opinion that these youth are being arbitrarily detained. And that's what I wanted to share with you, because in reality, these arbitrary detentions are still happening, and they're happening against the very vulnerable youth. Many organizations are speaking up about this, but the military is still illegally recruiting youth through arbitrary detentions. And this is making very difficult to provide real figures and real statistics. We have presented different requests to the military and to the Ministry of Defense, but we are always told that they don't have any registries, no cases of any claims regarding these arbitrary detentions. In 2018, we received a list of the different cases, about 20 cases of arbitrary detentions, but that cannot be a real figure. So this is what we wanted to talk to you about, to explain how we are trying to create a new strategy. And we want to do this through strategic litigation. We want to use this strategy to try and find new conditions that can help the youth in Colombia, that will enable them to, well, we can help them and guarantee a future for them.
Eh, Listo. Muchas gracias, Maricely y Alonso, por lo
Thank you
que
very much, Maricely and Alonso, for everything you've shared with us today. I think it shows that even when we have succeeded in some way, and when, for example, conscientious objection has been recognized in Colombia, there are still many other irregularities taking place, and these irregularities are affecting the youth. I think this really helps us to raise awareness about practices such as the raids. And I think we all grew up being aware of these practices, and we thought that these raids were normal, and they turned out to be illegal. And I think that raising that awareness has help civil society understand that that was an illegal practice and that those practices shouldn't happen. But it is true that the military has now found new ways. It has adapted and has changed its practices in order to overcome those legal barriers. And regarding what Alonso has said, it is true that conscientious objection is being used by the military. And like as you said, the conscientious objection is not just a formality, and it is a way of protesting, politically speaking. So